Good afternoon, everyone. This is Victoria Nalule. And today our webinar is on international arbitration in the African energy sector. And we have three panelists, including Mr. Brandon Malone, who is an arbitrator and also the chair of the Scottish Arbitration Centre. We have Ms. Mercy Okiro, who is an arbitrator and also a representative for the YAF. And also we have Mr. Nicholas Muhereza, a petroleum lawyer from Uganda. So this is part of the African Energy Transitions book launch, because Nicholas has a chapter there specifically on international arbitration in Africa. So we're going to have our guests to briefly introduce themselves, and then there afterwards, we shall start our discussion with Mr. Brandon Malone, who will give us a perspective of international arbitration in the energy sector. And then Ms. Mercy Okiro will come in with arbitration in the African energy sector, and she'll be able to refer to some energy cases. And then lastly, Mr. Nicholas Muhereza will highlight the key issues in his book, specifically with respect to arbitration in the African energy sector. Mercy, would you like to introduce yourself? And then afterwards, Brandon and Nicholas will follow.
Certainly. Thank you so much, Victoria, for welcoming me to this session. My name is Mercy Okiro, as you've heard. I'm based in Nairobi, Kenya. I'm a lawyer. I also practice arbitration, mediation, and construction adjudication. This is my first time to interact with energy arbitration at this level, but arbitration is nonetheless arbitration. So I look forward to learning from the rest of the panelists and look forward to engaging more with the participants. Thank you.
Thank you. Brandon, would you like to introduce yourself?
Yes, thank you, Victoria. Brandon Malone, as you say, I'm an arbitrator and a lawyer. I'm based in Edinburgh and also with Quadrant Chambers in London. I chair the Scottish Arbitration Centre, and also I'm a co-director of the International Centre for Energy Arbitration, which is a joint project between the Scottish Arbitration Centre and Dundee University, the Centre for Energy, Petroleum, Mineral Law and Policy, which of course you know very well.
All right, and Nicholas, please introduce yourself.
Yeah, thank you so much, our host, Dr. Victoria, and for organizing this great online seminar. My name is Nicholas Muhereza from Uganda. I'm a petroleum lawyer, lecturer of law, and a policy analyst. I think that's it for now, and I'm doing a book contribution together with Dr. Vicky and many other guys. And my contribution is specifically on the development of arbitration and ADR in general in Africa. And I'm looking specifically at the case study of Uganda. Thank you.
All right, thank you very much for the introduction. Now, Mr. Brandon Malone will start off with a discussion on international arbitration and referring to some cases in the African energy sector. We'll start with the introduction on international energy arbitration, basically. Mr. Malone.
Okay, thank you, Victoria. I'll attempt to share my screen. Can you see the slides?
Not yet, not yet.
Now?
Yeah, we can see them now.
Yes, very good. Okay, well, thank you for asking me to take part today, Victoria. I want to talk a little bit about energy arbitration. We'll talk about what the term energy arbitration includes, what kind of activities give rise to disputes to energy arbitration, what form does energy arbitration take, and what are the growth areas for arbitration in this area. So first of all, what does energy arbitration include? Well, it can come up in any kind of energy related activity. So obviously oil, also gas, coal and mining, nuclear, shale, wood, biomass, waste to energy, wave, onshore wind, offshore wind, tidal, hydro, geothermal, and perhaps a number of others as well. And in terms of activities, that can arise as a result of exploration, extraction, engineering, processing, generation, distribution. So many opportunities along the chain of production and distribution where energy can give rise to disputes. Essentially, there are two types of energy arbitration. We have investor-state disputes and then commercial disputes. So if we look at investor-state first, one of the reasons that energy arbitration or that arbitration is so popular in the energy sphere is that it allows for safe investment in states which may be energy rich, but which have courts, legal systems that are not as well developed. And there might be, for example, issues with the rule of law, with corruption, so that a company, an oil company, might be concerned about investing in that country. And the classic example is where an investor is worried about expropriation, so that if they go into a state, they invest a lot of money, a lot of infrastructure, and then the state takes over the assets of that company. So for example, if a large oil company discovers oil in a state and invests heavily in terms of its infrastructure to exploit that resource, with the blessing of that state, but then the state decides this company is making too much money, we're not comfortable with it, it might be politically unpopular, for example, that the company is doing so well out of the natural resources of that state. And they decide, well, what we'd like to do is to take over these assets, and they simply seize them with their military, perhaps. Now, that could be a breach of the understanding between the company and that state, or some sort of agreement. But where's the state, where's the company going to go to get redress from that state? Is it going to go to the courts of that state to try and get those assets returned, or to get some compensation? Well, that's obviously problematic. If a state is prepared to behave in that way and to seize assets, then it's quite possible, quite likely perhaps, that the state is going to be interfering with the court system, exerting influence over the courts, so that they're not going to get, the company is not going to get a fair hearing in the courts of that state. Is it going to go to its own host state? Well, there probably, or even a neutral state, there probably isn't much point in doing that, because states enjoy state immunity in the courts of other countries. So you're not going to get any success there. Traditionally, they might turn to their own host nation to try and get compensation through diplomacy, or perhaps even military action. But of course, that's not a very effective or satisfactory way to try and do business. So you can see how this might put companies off investing in an unstable state, a less developed state. So the solution is to have a system of treaties so that the investor in the state has protection where a dispute arises. And they can take the state to arbitration, which is not controlled by that particular state. So there's this objectivity and neutrality that ensures justice. So for an investor to go directly against a state, there needs to be some sort of multilateral investment treaty, like the ICEA Treaty, or a convention like the Energy Charter Treaty. And where a state is a party to the ICEA Convention, an ICEA tribunal will have jurisdiction where the dispute arises directly out of an investment between the contracting state and a national of another contracting state, where the parties have consented in writing to ICEA arbitration. Now, that consent in writing can be contained in the host's national investment legislation, so it doesn't have to be specific consent to that particular arbitration, or it could be in a bilateral investment treaty between the host state and the state of the investor, or it could be in a multilateral investment treaty like the Energy Charter Treaty. Talk a bit about bilateral investment treaties. That's between two states, which protects the investment of foreign nationals from one state investing in the other. It works in both directions, of course. It contains binding obligations on each party, providing qualifying investors with certain minimum protections in respect of their investments in a state with which the home state has concluded the treaty. And these protections apply regardless of whether there's a direct contractual relationship between the investor and the state where the activity is taking place. Now, most of these treaties, bilateral investment treaties, provide that the investor has the option of referring a dispute to arbitration under the ICSID rules, or sometimes an ad hoc arbitration under the UNCITRAL rules, or sometimes under, for example, the Stockholm Chamber or the ICC. There might also be a concession contract, and that's a direct relationship between the company and the state, which provides for arbitration. And the general idea is that investment treaty is affording protection to investors and therefore encouraging investors to invest in that state. It protects them against expropriation, nationalization, unfair treatment, where, for example, the company is put at a competitive disadvantage against, for example, a state-owned oil company or energy company. And of course, energy investment is a very common form of investment, and that's particularly the case in energy-rich African nations. We know that something like 25% of ICSID cases involve oil and gas and mining disputes, and that a further 15% of ICSID cases involve other energy disputes. So that's a brief overview of investor-state arbitration. If we look briefly at commercial disputes, now that can take a number of forms. Commercial arbitration is the other main form of arbitration, and that is between parties who are connected in a contractual relationship somewhere along the contractual chain. And it can, again, arise in a whole host of scenarios. Some examples on the slide: EPC contracts, energy procurement and construction contracts, gas price review, very common, certainly has been very common, dying down in some places, coming up in others. Joint ventures and joint operating agreements, regulated utilities, and decommissioning and renewables coming to the fore. You'll very often see an escalation clause, so that the parties have to use high-level negotiation and potentially mediation before they start. Now, it's not always, of course, the case that parties go to arbitration, particularly in the UK continental shelf, for example. People still use the courts widely, but arbitration is very widely used, particularly for international disputes, although expert determination is also used from time to time. Now, we saw that in the LCIA are reporting something like 38% of their arbitration is derived from oil and gas and commodities. We also saw, it's a while ago now, but in 2013, there was the Corporate Choices in International Arbitration report, one of the series of reports that Queen Mary University do on arbitration. And they found that 78% of respondents in the energy field felt that arbitration was well suited to their industry. I've also been involved in some research myself. There's the International Centre for Energy Arbitration, which I mentioned, a joint venture between the Scottish Arbitration Centre and the University of Dundee Centre for Energy, Petroleum Law and Policy. And Professor Peter Cameron of the centre and I are co-directors of that. And we did a report in 2015 where we found that there was strong support for arbitration as a method of resolving energy disputes. And in commercial arbitration in particular, there was an emphasis on factors such as probity of the court system and strong confidentiality, which might affect the decision of parties where to seat their commercial arbitration, which is always, of course, a difficult question. So, in conclusion, we are seeing, we are, of course, in an age of energy transition. That's the theme we're talking about. Massive emphasis on renewable energy, and we see that with more and more renewable energy cases, the Spanish solar energy cases, for example. I think we're going to see a growth in decommissioning disputes, particularly in older assets like the UK continental shelf, but also more generally because, of course, the viability of oil production, for example, is going to be affected by the lower price of oil and the low cost of producing, the lowering cost of producing renewable energy. the shift to the demand from oil and gas to renewable energy sources. And that's all putting pressure on the price of oil, and therefore the level at which it is profitable to extract oil and gas, particularly when you're extracting offshore where the price is higher. So I hope that gives you a useful general introduction to arbitration in this area. And I will now turn off my slides.
All right, thank you very much, Brandon. That was really a very excellent presentation. Now, we'll take in questions at the end of the presentation when everyone else has presented. So at this juncture, I would like to invite Ms. Mercy to also take us through the issue of international arbitration in the African energy sector. Mercy, are you on? Okay.
Yes. Thank you, Victoria. And it's a good thing that Brandon has presented before me, because he's given an overview. So whatever I wanted to say, he's covered at least the introductory parts. So I will quickly just get into the dispute resolution. My apologies, I don't have slides, but as we spoke, I will send you my document because it was a Word document. Then you can circulate to the participants. Now, dispute resolution in the energy sector in Africa basically either is commercial arbitration or investment treaty arbitration. Well, I will discuss this later, but whereas there has been movement towards resolution in local courts, as has been said by Brandon, investment treaty arbitration and most agreements refer to international arbitration, such that you find parties, whether it's investor state or state, most of the times they refer to well-known rules. Well-known to mean maybe the London Court, the ICC, the UNCITRAL rules. That's one point. The reason for this choice is usually because I don't know how to call it. I don't know whether we have no faith in our institutions, but also the foreign investors do not trust local courts, because courts in Africa have been known to have interference from time to time from the executive. That's one thing. This is also, I find it not, it's a very contradictory point, because a good number of African states have signed the New York Convention on Enforcement of Arbitration Agreements, awards rather. And in investment treaty arbitration, you find that over 500 African states have actually signed bilateral investment treaties and international investment agreements, not just within the continent, but most of these, the 500, are actually with countries outside Africa. Also, we have at least 43 countries in Africa that have adopted investment laws and codes with a specific regime for FDI. Further, we also have local, I'd say, commercial arbitration also is used rather. So more or less it's investment treaty arbitration, commercial arbitration. Now, because the time is really not on our side, I have to speak quickly. I'm assuming that the nature of the three main types of disputes that involve African parties are going to be discussed by Nicholas, because I have glimpsed into his book chapter. I will discuss the issue of current issues and future trends that are happening in the sphere of arbitration in the energy sector in Africa. The first thing is, I'll use the example of the Tanzania. Let me just look at, quickly highlight 3 cases. This year has not been a very good year for Tanzania in terms of claims against the government or state, as it may be. They have had 3 notices to commence arbitration, international arbitration, seeking compensation. There was a notice from a Canadian firm in January, and another second one from a subsequent Canadian company. And later, in line with the UK Tanzania BIT, there was another claim that was going to be instituted. Now, the amounts of money that were being claimed against the Tanzanian government, if these awards are issued in favor of the investor, the Tanzanian economy could collapse. As a result of that, Tanzania decided to take steps to try and ameliorate the situation, if at all, rather mitigate. First of all, Tanzania has enacted an investment arbitration law. It's not just investment arbitration, but generally an arbitration law. For those who know, Tanzania has been behind in terms of enacting even a modern law, not just on investment arbitration. It's also trying to negotiate with one of the Canadian firms so that they can settle in mediation in one of the claims. And a good example that we all know is South Africa. In 2015, the South Africa basically withdrew from its treaty obligations and canceled several bilateral investment treaties. And in its new investment law, basically it focuses on fork in the road provisions such that you can only resolve these disputes by recourse to local mechanisms. And even when it's you want to use international arbitration, the state has to consent. So basically in South Africa right now, more or less they're saying any investor with an issue in any BITs or any international agreements regarding anything with investors moving forward, you have to basically use local mechanisms. Tanzania also, in its new law and also in its amendment in 2018, basically has also provided that all investments be handled by Tanzanian arbitration institutions, which has led to now the publicity of the Tanzania Institute of Arbitrators, which wants to step in, so that it's basically the one that accredits mediators, arbitrators, that will be in charge of these disputes in future. Another thing in Africa, African countries are also moving east in energy arbitrations. They are no longer looking at the original, quote unquote, that was seen as popular destinations for arbitration in energy matters like London, Paris, Switzerland, and basically the quote unquote the Western world. African countries now are moving east in terms of pursuing having arbitration, international arbitration in energy matters in Singapore, Hong Kong, and basically Asia. Increasingly also local arbitration institutions such as the Nairobi Center and the South African Center are also looking to have, actually the Kenyan has already entered into a MOU with the China Arbitration Center, so that moving forward, there's a joint committee where arbitrators will come from one of the two centers with the chairperson coming from another. The two of them will appoint that arbitrator. Because also you have to be cognizant of the fact that the FDI coming into Africa currently from China is a lot. So that is also has contributed to the movement towards East. The cost of arbitral proceedings also is high. African countries, as much as the economy is growing, increasingly African parties prefer not to go to international tribunals. So there's been a call to develop our local institutions. Currently, we have at least 77 arbitration institutions in Africa. I know those are many, but we have the main ones like the Cairo, the Nairobi Center is coming up, Kigali International Arbitration Center, the South African also, I also have a center. So increasingly, Africans and Lagos, of course, we want to grow our own local institutions so that we can have these international arbitrations being seated in African countries and also venues here. Also, there is an argument that has been there, which I personally support, the issue of diversity and inclusion in arbitration in energy matters, which basically is international arbitration. The number of arbitrators who sit as arbitrators in energy arbitrations are not so many. Africa, basically, we find ourselves increasingly having more and more claims before these international tribunals, but arbitrators from Africa are not picked. So it makes us who practice arbitration on the continent become salty one. Governments also feel that they do not get fair justice and they don't get fair treatment in these international tribunals because Africans are not there. So increasingly there's that move to look at either finding a way of having Africans appointed on these tribunals or basically just pulling these matters and changing to local, more or less African institutions. The issue also of experience, there have been calls that arbitrators in Africa are not experienced. That is why they're not able to be appointed in these international tribunals. Also, you find even governments such as Kenya, when we've had international arbitration matters such as the Kotek mining case, we have instructed counsel who are not Kenyan And Nigeria also, which I will highlight shortly in their P&ID case, which really is a hot topic right now. So that those issues, so we wonder, do we not have the requisite qualifications as either counsel here or even as arbitrators in Africa? Or is it an issue of always thinking that maybe the solution is from outside and not within? Court support for arbitration process has been an issue. That is why, as much as the signing of the New York Convention.
Sorry, let's wait 2 minutes to summarize.
Okay, let me just go to the case law. The one hot cases, of course, Kenya, I'll speak quickly on behalf of Kenya. The Kotek mining case before the ICSID tribunal moved, basically touched on issues of cancellation of a mining license, and the tribunal ruled in favor of Kenya, saying that even if it's a foreign investor, environmental impact assessments, which form part of domestic law, have to be adhered to. We won that one, but now there's a claim for, there's an application for annulment for ICSID. There's also the one for the famous, we call it Kinangop case, the windmill, or the geothermal prospecting scheme. We got into this contract with foreign investors, and they issued, they went against us in a claim, claiming that we'd cancelled their license. But yeah, it was also upheld in favor of the Kenyan government. The Nigerians right now are the ones who are bearing the brunt. The South Africans have had their fair share. South Africa meaning the Southern Africa part. The Nigerians right now have a $6.9 billion award against them. And yes, they've set down 200 million as security for costs. And the more and more this issue keeps developing, it is now alleged that this company has never even done any other similar work. There's allegations of fraud. Just the other week, the UK court issued orders so that accounts of senior Nigerian officers can be looked at, the ones who allowed this contract to go on and entered into that agreement. So that now it's also turning on the wheels of fraud. So there's that. Before Nigerians can breathe, there's also another impending claim that is for debt collection that started as an agreement in a sort of loose investor-state agreement, and now it has become it's morphing itself into an international arbitration. So my conclusion is this. I've spoken really fast. My conclusion is this: moving forward with the changes that African countries are making in terms of improving their laws, reviewing their bilateral investment treaties, and even establishing multilateral investment treaties, and even with the coming of the AFC, the African Continental Free Trade Area, and the dispute resolution mechanisms therein, Africa needs to now decide. We either streamline our international arbitration mechanism under the Continental Free Trade Agreement area, or consolidate whatever we have regionally between ASDC, ECOWAS, so that there's uniformity, because that's one of the problems that we have right now in arbitration in Africa. There's no uniformity, there's a proliferation of too many institutions. As for standards, I believe we have the standards, and increasingly we are looking into issues of corruption by signing anti-corruption codes and also developing codes of ethics for arbitrators. I will stop there and I will send my slides. Thank you so much for the opportunity, and I look forward to answering any questions, though I did not manage to cover everything. Thank you.
All right, thank you very much, Mercy. So as we're having Nicholas to start his presentation, I would encourage you, Mercy and Brandon, to look at the Q&A and try to respond to some of the questions that have been raised. You can type in the answers, and then afterwards we shall take in the general questions. Nicholas, could you please make your presentation?
Yeah, thank you so much, Dr. Victoria, and the previous panelists. My name is Nicholas Muhereza, and I'm a petroleum lawyer, as already introduced. Basically, most of the things actually have already been discussed or touched by my colleagues who are actually who did a very good job, Brandon and Mercy. So I'm basically going to look at one of the reasons why we are having issues on the continent, specifically looking at the case of Uganda. Why do host governments and IOCs have come, or why do they have disputes? And I'm looking at three major areas, and one of them is the change in the laws of host countries. Mercy already referred to Tanzania, which has had to revise its laws regarding arbitration. In Tanzania, if a host government and investors or international multinationals have challenges to do with the available legislations or any agreements which they have entered to, then there is no amenity of going to international arbitration places like the London Court of Arbitration or the ICSID or anywhere. It must be resolved in Tanzania. So that is one of the outstanding areas I wanted to cite out as one of the reasons why we are having disputes when it comes to energy investment in Africa, and also affecting the wider development of arbitration in Africa. So once investors come into a particular place, they expect a certain regulatory stability so that they can be able to recoup their investment in the long run. So in situations where you find African countries or host nations are changing the laws day and day, then that definitely becomes a good ground for causing disputes in terms of investments or FDIs and host countries. So I think that is one of the major areas that host countries away from Uganda and other countries in sub-Saharan Africa and Africa at large to look at. That once you have brought in an investor and then there is a necessity to change the laws without consulting the investors or the multinationals which are investing in our energy sector, it is important to consult them and try our level best to ensure that there is no regulatory changes that are uncertain or have not been put into consideration at the time of the investment. Then the other area I want to look at is acquisition, or what Malone talked about earlier on as one of the causes of arbitral challenges or challenges brought in various international bodies is what I would call as expropriation, as we have seen in various countries. If you remember what Libya did during under Muammar Gaddafi in the 1970s, when they had just finished the revolution, they took over 51% of most oil investments that had been brought in by foreign investors. That itself really was a bedrock, or was one of the major causes of the instability now we are seeing in Libya. Even in Venezuela is a good example. Venezuelan government has done the same. So it is one area which has really brought in major conflicts, and which most resource-rich countries need to take into consideration as whether nationalization or expropriation is worthwhile. Is it worth the monies that come out at the end of the day in terms of arbitral awards that host countries should be trying to avoid by all means? Then the other area which is affecting Uganda specifically is which I'm looking at in that book chapter is the payment of tax, the capital gains tax, which most companies, once they are transferring their interests, for example, in the situation of Heritage and Talo was buying the interests of Heritage, and the Ugandan Revenue Authority had to come in place to ensure that there is a capital gains tax which must be paid. At such situations, we find that the multinationals are not actually willing to, or are not happy to pay certain exorbitant tax that is levied by host countries. So in such a scenario, how do you build the coherence, or how do you bring all parties on table to ensure that there is no conflict and relationships are maintained, since most of these multinationals invest for a long period of time? So payment of taxes, regulations, and then of course acquisitions by host countries or expropriation, be it 50% or even 100%, are one of the major areas which I feel should be looked at in terms of the development of arbitration in Africa. Then if you were to look at the previous point I talked about, like countries which have changed their laws and regulations to limit arbitration beyond their domestic boundaries, I think that is quite dangerous, because it is high time, in one of my conclusions in my research is that it is high time African countries looked at international arbitration or commercial investment, commercial arbitration as one way of inviting or inspiring investments in our resources, because we understand Africa is actually a very resource-rich continent. But if we are to keep on seeing international arbitration as against African countries, then I think in one way or the other we shall be discouraging investment. So the point is that international investment arbitration, according to the agreements that have been signed between host countries and foreign investors, is one way of actually encouraging FDI, or foreign direct investments. So that is basically the most important thing I would say will lead to future development of arbitration in Africa. And then we have centers in Africa. If it means that the London Court of Arbitration or the ICEA or anywhere, be it in France or where, we still have to develop our own centers of arbitration. For example, South Africa. One of the panelists talked about Cairo, I think, which has one of the oldest centers of arbitration, which has been there since the 1979. Then South Africa. Then Nairobi here, I think, also has a good one. Even Kigali. But I think the most favored one in Africa has always been Mauritius, because it tends to combine both the French and English legal systems, which of course covers most of the rest of Africa, and has indeed hosted several arbitral challenges which have been brought in by different stakeholders. So I think there is a development as well. If you have to look at the particular disputes that have been brought, for example, taken to London or to the ICEA, you see that each and every passing year since 2016, 2017, there is an improvement in terms of the trend. You see that every year that there is a development in terms of the trust. And also, if you are to look at if you are to look at the African arbitrators that have been appointed, for example, at the UN body for arbitration, it has also improved. So by and large, despite the challenges and the changes that are brought in by protectionist countries or host countries like Tanzania, I think at the bigger picture, you have to say that indeed we are on the right track. If we are able to avoid areas like trying to stop companies from going to places where they are comfortable to do arbitration, I think by and large, I must say that Africa is on the right track. So thank you so much. That's the brief or summarized recap of what Africa is undergoing, and part of what I'm researching on in the development of arbitration in the African energy sector. Thank you so much.
All right. Thank you so much, our panelists. I noticed Brandon and Mercy have been able to respond to most of the questions that have been raised, but I see a question with respect to the African Free Trade Agreement and how arbitration is likely to be affected. Mercy, would you like to respond to that? And also on the new bill in Tanzania that is against arbitration. So I'd like Mercy to respond to that, as we're going through some questions that haven't yet been answered, and Brandon and Nicholas will also be able to respond afterwards.
Okay. The dispute resolution mechanism under the, you can hear me, yeah. The dispute resolution mechanism under the African Continental Free Trade Area is basically state to state. And now the state has basically, sorry. So with the treaty having been ratified by the minimum countries, this mechanism can roll into effect. So that right now, what the Secretariat is doing is working on now coming up with a proper mechanism for that dispute resolution mechanism. In this case now, of course, state to state, it will be arbitration, and also mediation will be explored, because as the African Union came up with the Pan-African Investment Code, mediation was highly favored, and actually arbitration. And more importantly, the code insists that, basically not insists, but kind of implies that African states moving forward start picking African seats and venues for arbitration and African institutions, basically. Given the backlash that international ISDS has received in the few years, just even looking at the Latin America, Africa, South Africa has led the way. Namibia has done a few amendments to its code, Ivory Coast. So with AFTA now kicking off, state to state is going to be there, and it's going to be arbitration. Now, the main question is whether moving forward, African states will now prefer to explore arbitration regionally, that is according to the Pan-African Investment Code, or still have that in concurrent with ISDS as it has been before. So arbitration will still be used. Actually, most of the people in that dispute resolution mechanism, the stakeholders, want to have a provision for mediation and arbitration. However, the issue now is, will it be in Africa, or are we going to stick with the former ISDS mechanisms where more or less it's been ICSID and CITRAL and venues and seats, everything outside Africa? Regarding the Tanzanian bill, it is now an act, if I'm not wrong, actually. My comments on that is this. Tanzania needed an arbitration act, first of all, whether or not it's because they've been served with 3 intentions to commence arbitral proceedings. My thing is, I feel that perhaps they should have been more balanced in regards to protection of the investor and also the host state's interest, because now it looks as though they more or less want to lean towards the South African direction, where the state is the one that basically runs the show. So that right now, what does that then mean? It means that foreign investors will be very wary of investing in Tanzania if now they're subjected to that investment act, the investment law, where basically all disputes will be settled there. They'll be chosen by the Tanzanian arbitrator institution, and more importantly, they'll have to be accredited by the Tanzanian Institute of Arbitrators, or whatever institution that the government decides. Currently, there's only the Tanzanian Institute of Arbitrators anyway. So if that is what the government decides, will now pick arbitrators in Tanzanian disputes. Foreign investors may not be very comfortable, because you see the whole operation of investor-state relations is protections on both sides. So that if the state's interests seem to be the ones taking over, the Tanzanians may maybe suffer a bit of backlash, and especially influx of FDI, because FDI, basically investors cannot bring FDI to a country where they know if a dispute arises, they have very little wiggle room in terms of dispute resolution. So I'm just waiting to see the developments, because there's a lot of talk about the Tanzanian law. Maybe they'll amend it, I don't know, but as it is, they are more or less taking South African direction. And also, as you realize, Tanzania also, the government has a lot of say in nationalization of investments and such issues. Yeah.
All right, thank you very much, Mercy. I'd like Brandon to address the question from Abdi, who's asking, how do you address the question of stabilization clauses vis-a-vis the host country's right to change their local legislations and arbitration platforms? And then after Brandon has addressed that, I would like Nicholas to address the last question with respect to how do you foresee the role of domestic arbitration in the event foreign direct investment increases in the country? So Brandon and Nicholas.
Thank you.
Sorry, Brandon, I think you're muted.
Okay.
Yeah, we can hear you now.
Yes. Okay. It's a very sensitive and difficult area. The stabilization clause, particularly as society moves forward, and we've seen this in so many cases where the view of the electorate develops over time as political priorities change. And so you have a tension between two legitimate interests. You've got an investor who expected a certain state of affairs when they became involved, and you have a government who very legitimately wants to move their legislative framework on, as whether it's science has moved on or political opinion has moved on. So you have to be very careful with these freezing clauses and try and find a way of resolving these disputes when they come about. But there's no easy answer. Are we still there?
Yes, yes. Sorry, Brandon, were you done with your response?
Yes, sorry, that was my short answer.
Oh, all right. Sorry about that. Nicholas, do you want to address the questions that
Yes,
have been
thank
raised?
you. Yeah, thank you so much, Dr. Vic and my fellow panelists. The question is that, is increasing FDI likely to be more successful if one relies only on domestic arbitration? As I said in my concluding remarks, FDI and international commercial arbitration are related. You cannot separate the two. I mean, no serious investor wants to come into a particular country and invest their massive amounts of billions of dollars, well knowing that in case of any disputes between themselves and the host countries, that the matter will particularly only be handled by the local courts. We all know that in most African legal jurisdictions, there are problems with the backlog of cases, that these courts or even arbitral bodies like our own body here in Uganda, which handles arbitration, be it the Uganda Arbitration Center or even the Tax Appeals Tribunal, which has previously handled matters to do with the petroleum disputes, that is Uganda and the oil companies. We have a backlog. There is a challenge, not even forget the backlog. How about corruption? I know this is something that we wouldn't want to be saying in public, but it is well known, it is a public secret that we have challenges to do with transparency. So how would you trust, or how would you invest your monies in a country, for example, now Tanzania, that has come up with proposed the law to completely do away with international commercial arbitration? I think that it is an automatic discouragement of investments. Of course, for the companies that are already in the country, will possibly have no option, or maybe they will have to pursue legal means of challenging such legislations. But like Brandon talked about stabilization clauses, a stabilization clause itself is not the end in itself. Even if companies agree to stabilization clauses, I think if you are to look at international law, still countries, I think, have a right to come up with under ownership or that the ownership of its own, the day-to-day running of the state. I think a stabilization clause itself is not enough. That's why you have seen countries come again, taken over assets of oil companies or mining or other energy companies. So at the end of the day, it's not about limiting arbitration, but opening up, because it is opening up that indeed African countries have realized that through opening up, then FDI is just, it's really a matter of time that most international investors will want to deal with countries that favor international commercial arbitration. I hope
All
I'm
right.
clear here. Thank you.
Thank you very much, Nicholas. We shall just get a few remarks from Leonard, who has asked to make a few comments. Leonard, if you can do that, and then our panelists will make their closing remarks, and that will be the end of the webinar.
Yes, good afternoon.
Victoria,
can you hear me?
Yes, we can hear you very well.
Yeah, thank you, Victoria. Now, one of the participants of the Salam application of stabilization for urban clause vis-a-vis the host clause rights to change their local legislation and arbitration platform. My argument here is that the premium clause gives the state has a right to amend laws, change laws, because some of these laws, for example, they affect the environmental issues, some affect social issues. So the state can amend laws. However, when the state amend laws that literally affect the investment of foreign investors, the state has to compensate or return the investor into a position where he was before that law was amended. So when you're balancing this, because the issue of, there's a case in Philip Morris versus Uruguay, where the tribunal stipulated that despite the fact that we have that is EFET does not stop states from literally amending laws as long as those laws are equitable and fair to the needs of that given state. So there's a balancing. So we can balance this issue of changing of laws vis-a-vis stabilization clause, because at the end of the day, arbitration does not mean that you'll have to go to the arbitration just because a state has changed a law that has literally affected the investment. Because tribunals will not give you any award as far as that is concerned. So that is my response.
All right, thank you very much for the contribution. Now we shall have our closing remarks, and I'll start with Mercy, just 2 minutes to make your closing remarks, and then Brandon, and then lastly Nicholas, and then that will be the end of our webinar. And please do not forget to subscribe to my YouTube channel, Victoria Nalule. We have several videos on international arbitration in the energy sector, featuring Brandon Malone and also Professor Peter Cameron. So definitely you'll have a lot to learn from that YouTube channel. So Mercy, would you like to make your concluding remarks, please?
My concluding remarks are this. Right now, with the coming in force of the Continental Free Trade Agreement having been ratified by enough number of states, I feel that this is the time for African dispute resolvers to start looking at how they can contribute to the dispute resolution under that agreement. Secondly, African countries must enact modern arbitration laws and also investment laws. Further, in terms of reviewing bilateral investment treaties and even looking at regional, multilateral investment treaties, whether regional or whatever, African countries must then now equip themselves with the requisite skills. In terms of negotiations, I will say this, and the Nigerian my Nigerian friends in the chats can confirm that issues of negotiations in investment and international investment treaties by Africa, sometimes people who negotiate these treaties do not understand the issue very well. Even when disputes have come in before international tribunals, sometimes also we instruct people who do not understand this regime of law properly, which ends up leaving us with some very colossal awards against African states. Second last, while reviewing bilateral investment treaties and just our treaties, international treaties, moving forward, international investment treaties, we need to look at new things like environmental protections, social responsibility, and human rights. These are things that now are hot, and as Africans who are now interested in this area, we need to look at. Lastly, to my young African counterparts on this webinar and anyone else, one of the reasons why we complain that we don't have enough Africans out there is because also the interest, people like Dr. Victoria Nalule and a few others who've now taken this issue and studied either arbitration or just issues of energy, oil, gas, and the entire spectrum. We need to get involved so that in future we are counsel, in future we are arbitrators, in future we are the ones negotiating these treaties, and doing it not only from a point of being African, but we're doing it from a point of knowledge. So that is my closing remark. Thank you.
All right, thank you very much, Mercy. I like the last point of Africans getting the required experience and also education in order to take up these roles. Because it's one thing to complain that we have no opportunities, and it's one thing to be ready to take up the opportunities when they avail themselves. So Brandon, would you like to make your concluding remarks?
Yes, thanks, Victoria. I mean, I think these are very important points, and it's come right through the webinar. I mean, I direct a conference every year. We haven't done it this year for perhaps obvious reasons, but you've spoken at Victoria, and this theme of the legitimacy of arbitration in Africa is something that keeps coming through, because Africa and African nations generate a lot of arbitration. And African nations ought therefore to be getting the benefit of the arbitration that is generated by this economic activity coming out of Africa. And there's a lot of strands to that. Yes, it's very much about African lawyers getting involved. There's institutional strengthening that's required, and that kind of thing can come around through co-counselling, for example, at least in the interim, so that international firms are working with African firms. And it's important that the international firms do not see this as them diminishing the work that's available to them, but actually, if the acceptance of arbitration grows and the acceptance of international arbitration norms grow throughout Africa, then that whole world of arbitration is going to expand. I think it's unfortunate to see some of these restrictive practices where I understand the motivation for it, the protectionism, but ultimately that's not the road to success in international arbitration. It's about being open to investment and giving the best protections. It's about engagement with the international arbitration rules. And I would hope to see more and more of that, and to seeing African nations, African arbitrators, African firms becoming fully operational within the international arbitration scene. And ultimately, you know, as the arbitration scene globally develops, what one would hope for is a fully distributed economy of arbitration, so that we see arbitrations which have no connection with Africa taking place in Africa, just as we see arbitrations that have no connection with London, for example, taking place in London, and arbitrations that have no connection with Singapore taking place in Singapore. Why not also in Africa? And the way to achieve that is not to withdraw, but to engage and to fully become part of the international arbitration regime, to have the rule of law rigorously upheld throughout nations throughout the world, and that is where growth in the industry and growth in economies is going to come from.
All right, thank you very much, Brendan. And Nicholas, would you like to make your concluding remarks?
I really don't have a lot to differ from my colleagues, but I would also want to emphasize the idea of capacity building. That once Africans are able to, for example, as I already said, that if you can be appointed to go and join the International Court of Arbitration, for example, the ICC, yes, that one, where Africans have recently been appointed also to be part of, even including Ugandans, our own Ugandans here, that even when you are to go, for example, to London in arbitration, you can still go there and win a case against an international multinational or an international company which is worth billions of dollars. Like we did, you remember the famous handshake in Uganda, that actually our own people here went from here to London and won a case. And Uganda was successful. So I think there's no need to fear to go to international arbitrators if we have the capacity. As they already said, we can see Dr. Victoria is well representing us in the UK. You are hosting such massive webinars, international seminars, even in the wake of COVID. we have people we can learn from, like Brandon Malone, the great Peter Cameron, and several other great people beyond the continent. So it is high time that African nations looked at investment arbitration, or the clauses they sign to. They shouldn't be wanting to turn against them when they feel there is a lot of money at stake. Instead, we should build capacity, and there shouldn't be anything to fear indeed, because we have previously won cases in these international arbitral bodies, so there shouldn't be any cause of alarm if we have the capacity. Thank you so much.
Thank you very much, Nicholas. Thank you very much, Brandon, and thank you very much, Mercy, for the great presentation. For those who would like the slides, you'll have to email me. I'm sure you have my email address, and then I'll send you the slides. And this marks the end of our webinar. Do not forget to attend another webinar on the 16th of June. That will be Tuesday, next Tuesday. And here we're going to tackle the issue of nuclear energy, because in Africa, we're paying little attention to nuclear energy developments, and yet we have countries that are rich in this resource. So we shall discuss the issue of nuclear energy and how the role it can play in tackling energy access challenges on the African continent. And then on the 15th of June, we shall also be discussing one of the chapters in our book, which is very important because it's focused on social license to operate in the oil and gas sector. So we need to really understand the relationship between international oil companies or mining companies and the local communities, and what really needs to be done by policymakers. So do not forget to log in. It will be the same link, the same Zoom link. And then on the 30th of June, I'll also be on a panel discussing construction minerals and legislation, because that's also one field in Africa that we're not paying attention to. And yet we know sand is a main resource that is likely to play a crucial role in the anticipated urbanization on the African continent. So we'll be discussing several topics that we feel are relevant for Africans or African policymakers. So please do not forget to subscribe to the YouTube channel, and also let's connect on LinkedIn. You can also connect with all the panelists on LinkedIn and follow them so that you get updates on their work with respect to arbitration. Thank you very much. This marks the end of our webinar, and have a good evening. Bye-bye.
Thank you.
Thank you.
Bye.